Rohit, you can start.
Yes, sure. Good evening, everyone. This is the second live session on the course of Advanced Contracts for Public Procurement. I think it's a pleasure to see that so many participating persons have joined this session. And before we move on, I think I have a particular insight that as to how we would be discussing today's live session. So we have divided the session into 2 halves, wherein in the first half, myself, I will be discussing about contracting for startups. And in the second slot, we have Mr. Vikas Gehlot, who would be dealing with regard to public procurement and certain other intricacies therein involved. So let me just share the screen. Do confirm to me if the screen is visible. Is the screen visible? Yes. So if you look at it, one of the classic aspects as to why contracting for startups is different from contracting for other businesses are, it's quite there right on the screen. Because for a large business, for a conglomerate, contracting is a routine task because, business is quite affluent, one or the other transaction keeps popping up. But for small businesses, every single contract is a huge, turning point for its business. Okay. So if you're going to, it could be with regard to hiring an employee, it could be something regard to renting an outlet. It could be with regard to purchase of a particular vehicle or machinery by way of a loan or something of that sort. For a smaller business, each of these agreement has a capacity to either make or break its business. So therefore, contracting for startups is something that you might have to look at it from a different nuance altogether. Can I request the participants to mute themselves? Yes, thank you. So now, before we move on to the topic, I would like to tell a little bit about our center. So this course is organized under the aegis of Professor Sairam Bhatt, who is the coordinator for the Center for Environmental Law, Education, Research and Advocacy at the National Law School of India University. So NLSIU is one of the premier law schools across India, and we are happy to host this course in association with NPTEL. And we have a couple of research databases that we would like you learners to visit and access. So as I speak, my colleague Vikas will be putting up the website in the chat box. So we have a dedicated publication database, nlspub.ac.in, which has access to all our research writings and publications, including a book called Public-Private Partnerships in India and Contracting in the Energy Sector, and also a book which is a compilation of various articles on contracts and public policy, which I think as readers or students of contract law today, you might be interested to take a look at. Without further saying on what we are and what we do, we will move on to what are the various kinds of startups that we have. I think any Bollywood movie fans here in the house, if you could just raise your hand, probably it would be good. Yes, Bollywood. Yes, okay, I see one person has raised their hand. So, which is an ideal startup? So probably I think that is something that might go into our head, because we see that there are a lot of startups. You see that Tesla is a startup, and then you see that Apple was once a particular kind of a startup, which are, path-breaking businesses. So what is an ideal startup, if you would ask me? So I would put across the startups that I know in the following three heads. Any idea what movie this is?
Hum Saath Saath Hai Saath.
Yes. So as the title goes, this is a kind of a startup which has only family members. So if you are a large group of family, so the entire family gets into this business. So that is what this startup is about. What is the next kind of startup that you can see today in today's ecosystem? Any idea what movie this is?
हम आपके हैं कौन?
Yes, exactly. So you guys meet, the two founders meet somewhere in kind of a mentorship cell, or probably in a research library or somewhere. They realize that they have similar ideas, but they are not related to one another. But yet they decide that let us do something together and take things forward, right? So this is another kind of startup which you actually see in the ecosystem, where two unrelated parties come together and do business. What about this one? Any idea?
This is like a Dil Wale Dulhania wali.
Yes, exactly. So like it says, the couples, power couples, they decide that they're going to start a startup. So husband and wife come together and start the business. These are the various combinations of a startup that you can actually see in India's ecosystem today. Can I have a similar contracting nature for all of these startups? What do you think? In a startup with a husband and wife, do you think the contracting ratio will be the same as that in the case of a startup where there are family members, or in the third category where two unrelated parties come? Please look at the manner in which contractual drafting changes, with each of these kind of startups. Now, this is just an introductory framework so that you understand how your contractual drafting will vary from one startup to another. So it's not a straight jacket formula. So you have to tailor make every agreement for each particular startup, depending upon what its nature is and what its activity is also. If suppose it's into a manufacturing activity, it's a completely different ballgame. If it's a service related activity, you will have to draft it in accordance with its service carry, right? So with that, we will move on further. Yes. So at what stages do you generally get an employer and an employee contractual relationship in a startup? So the first thing is with regard to the pre-hiring stage. So sometimes, what happens in these cases of startups is they require good quality people to come and work with them, right? So there is an instance where you will get into an NDA, because startups, the major funda is their idea. It's not anything more, anything less. Because startups do not have clients in the first beginning initial phase. They just have an idea in their mind. So at that point in time, engaging any person or discussing your idea or product with any person is a potential risk for you. So in the pre-hiring stage, one of the foremost important documents that become necessary for a business is your non-disclosure agreements. Any idea what is a non-disclosure agreement? What do you think is a non-disclosure agreement?
Non-disclosure agreement is basically a kind of agreement that restricts someone from disclosing any potential proprietary or otherwise information about an organization.
Okay, excellent. Can I restrict someone from disclosing what business I am doing if it is otherwise available on the public domain?
Yes.
If otherwise available on public domain, the NDA cannot restrict it.
Yes. So always note, there are limitations to each agreement that you have. Like say, for instance, if I am surfaced with a notice from, let us say, an authority, like say, for example, the police or the enforcement directorate, asking me to disclose certain transactions as to what is the discussion that I've had. In those circumstances, I might have to go against the non-disclosure agreement and reveal whatever the discussions were. Now, you might be coming across on the newspapers that there are several thousands of fraudulent companies that have been making use of co-working spaces. Right? So in those circumstances, all these co-working spaces would have definitely executed a confidentiality agreement with those companies that are fraudulent. When the cybercrime police or the enforcement directorate come and ask these co-working spaces for information as to who is the promoter of these companies, how are they remitting the rental amounts to you, all those information will definitely have to be disclosed. Now, that is one of the aspects that you need to look at when you're looking across what is the scope of the agreement that it can restrain to. The non-disclosure agreement, however, can restrict a person from disclosing with any competitor or any other business entity who can be a potential competitor. Please look at it. It can also apply against competitors as well as potential competitors. So that is how you can go about in the aspect of drafting, the extent to which you can make it. And also always remember that when you're drafting a clause, there has to be a term that is prescribed for it. Now, unless you say that the non-disclosure agreement is valid for X period amount of term, okay, the validity of it will be silent. So there is always a necessity to ensure what is the term or duration for which you want parties to be bound with each other, right? So that comes across in the pre-hiring stage. That is one of the 4 most important documents that you have to take note of. The next set of document comes across in the employment stage. So you have had a discussion with the prospective employee. You feel that he's perfect for your organization and the business decides to engage him. So now that is the point in time when his employment contract or service agreement comes into picture. Okay. So in those circumstances, what do you need to cover in your employment agreement? Of course, salary is one of the most important things. Probably that is what the employee is coming to you. But again, given that it is a startup, there may be a circumstance that your salary component is paid not in terms of money, but rather in terms of equivalent things to money. What could it be? It could be your shares, ESOPs. It could be, say, share warrants, scripts, or any other particular benefits, like, say, for example, house rent allowance, or it could be a company-owned car or something of that sort. Because in most circumstances, startups do not tend to give across salary. Okay, very rarely you find that startups actually draw salaries. So in that circumstance, your employment agreement will also require a particular redefined structuring that you might have to give. And please note, when I say startups, I'm just speaking about your early stage startups. I'm not speaking about startups who are getting their second series funding round or others, because that is the stage at which all these contracts get a revamp and money starts flowing into the company and you're able to meet a lot of different diverse aspects. The moment you get funding, the manner in which startups handle the matters changes, in the sense that before funding, all their activities happen in a dining room. Okay. But as soon as funding occurs, they shift to a boardroom. That is the difference at which, funding can create a change in a startup's ecosystem. Now, once this is done, you see that employees are hired. But however, a lot of startups, the risk that they face is that of attrition, in the sense that employees tend to leave the company in between, or they tend to go join a competitor. Is there anything that you can do to stop that? What do you think? Can I put in a restriction from my employee going and joining a competitor?
Yes, it can be put.
It can be put, but is it enforceable?
It is not enforceable, but initial the contract, you can mention that the employment will be subject to so and so. However, if you don't do this, you have to pay the penalty or something.
Okay, so I'll come back to those particular points. Please note, my friends, while you can put those clauses, whether it can be enforced or not, that is a question mark. Now, I'm sure that you must have understood what is the definition of a contract. A contract is something that is enforceable by law. So if something cannot be enforced, do you think it is a contract? Probably not. So conditions like the employee shall not join the competitor and other aspects, the enforceability is a question mark on those. It will never be enforced because they are particularly agreements in restraint of trade or employment, which is categorically expressly stated as void under Section 27 of the Indian Contract Act. But what do you do in the termination stage? What can you ensure that the employee is bound? Have you heard of something called a non-disparagement agreement? Now, NDA, the first NDA that I spoke about was a non-disclosure agreement. This is a new form or new age of NDA called the non-disparagement agreement. Generally, when an employee is being terminated or an employee is resigning from the company, majority of the times the resignation is because salaries are not paid. There is an overdue of salary of almost 12 to 15 to sometimes 18 months of duration, and employee is fed up that my startup is not paying me my salary. I have a life to live, and that's the reason I want to exit. So in those circumstances, it may become necessary for you to enter into a settlement agreement. The settlement agreement ensures that the employee withdraws all claims against the company for a particular fixed sum of money. Now, when I say this, please note, no company can hire people and then end up, absolving themselves from all liability against salaries. This is not a scenario that any businesses can enjoy, including startups. Okay, but sometimes what happens is these businesses go ahead and tell, Mr. So-and-so, I don't have money right now. I cannot pay it to you. I'm also not drawing a salary. How can I pay you salary as well? But please note, the difference is the promoters or the founders of the startup are doing it for themselves. It's their business idea. But the employees are only doing it for the money. They are not interested in your idea or anything. They are just supporting you so that they reap something out of it. And if they're not going to get what they reap out of it, they are going to create problems to you at the time of termination. So at the time of termination stage, a settlement agreement is something that becomes absolutely essential for you to ensure that no further grievances or hindrances to your business occurs. And lastly comes to the post-termination stage. Now, like I told you, after termination, I don't think you can control your employee. Okay, but it may be necessary in case your partner, in case your close, friend who is actually working with you as a service provider, okay, or your business partner, like say for instance, in a lot of circumstances, what happens is the business is run by one, but support services are provided by other entities. Like say for example, operation and maintenance is given to somebody else. Premises are owned by me. So in those circumstances, I can actually impose conditions on the operation and maintenance personnel to not carry on similar business as mine. A non-compete clause. This cannot be imposed on an employee. Let me be clear. This is a clause or this is an agreement which you can execute with a service provider who is being associated with your business. You can do it with your shareholders. You can do it with your investors, but not on employees. A non-compete clause is something of that similar nature. Okay, but however, a poaching clause, okay, a non-solicitation we call it. Non-solicitation clauses can be uniformly imposed on everyone. Okay, in the sense that no person who is associated with you can solicit employees of yours. That is something that you can also make an employee bound with, because he is not going to be carrying on, it's not affecting his trade, it's not affecting his right of employment. It is only protecting your interests. So whatever is positive in protecting your interests without hurting an employee's rights is something that you can always impose within the contracts. So this is about your employer and employee contractual relationship. And with this, we'll just go further to understand what are the other modalities of contracting and the issues that are there. Yes. So now with this, we move on to certain nitty-gritties as to where, in what circumstances you can have different forms of contracts. Okay. So startups, there are various stages of a startup. So we will discuss about the various stages of the startups and what are the various agreements that come into place at that stage. The first stage is when you're setting up your startup or business, which we call the entity registration stage. What do you think are the various agreements that could come into this phase? Any idea? It could be an LLP.
So
Yes.
yeah, it depends on the type of the entity. If the startup is registering as an LLP, then there will be a partnership and agreement. If the startup is registering as a company, there will be MOA and AOA.
Yes.
And if it's a single proprietor, then there will be no need for any agreement.
Yes, excellent. So like our friend Pratyanik mentioned, it depends upon the type of entity you choose. Now, how do you choose the type of entity? Like I told you, if it is a family-owned concern, everyone's part of the same family, I think you could have a little flexible approach. You could also take up a partnership modality also. Or in case if you feel that you want to cover your risk to a great extent, then in those circumstances, a limited liability partnership is also a feasible mechanism. But the moment you are going to engage someone who you do not know or an outsider, in those circumstances, it is always preferable to have either an LLP or a company only, because you do not know the whereabouts of that other person. Of course, you do know them because you've been interacting with them, but you quite literally not know how they are going to be as a business partner. And you do not know because people immediately change their stance as soon as investment begins to come. Now, in one of the instances, what happened with one of my clients was they got a funding of 50 lakhs from the state government of Karnataka under the startup initiative. As soon as the funding came, the founders started nitpicking as to who should get a bigger salary. The impact of this particular arrangement was that the startup, even before it became materializing into a business, even before they could achieve something as a milestone, they withered away. That was mainly because they did not have a framework in mind or in place at the time of setting up of the business. A college dropout, another employee from a different company having a software background come together and develop the software. Had they had an agreement as to who is going to own the IP of this particular invention that they come up with, or this software that they come up with, should it be owned by the startup? Should it be owned by either of these founders? What is the royalty payable? In case they had it in place beforehand, probably today they would have been a successful startup. But because they did not have an agreement or a framework in place at the time of commencement, at the time of growing or scaling up in their business, they withered down. So this is one of the reasons I would say that it might be essential that you have something like a founder's agreement or a framework agreement in place, shelling out what every right of each of the person who is doing business together is going to be in clear and crystal terms. If it is an LLP agreement, generally all LLP agreements are only basically, they cover as to how your LLP is run. They are silent on various aspects. Like say, for instance, you will not have any idea about the salaries payable or anything. In most circumstances, some LLP agreements included within the agreement itself. But let me tell you, that is not a good way out. Because every time you're going to increase somebody's salary, you will have to modify your LLP agreement each time. So always you should create these agreements that relate to the formation of entities as broadly worded as possible so that you can take up action points on a regular basis going forward once the business is set up. So couple of things here.
Just come in, Rohit, here.
Yes, sir.
So, I think it's important for us to understand that contracts are of certain categories. First of all, we have to understand that there is something called B2E contracts, which we say business to employee contracts. So a startup having a contract with its employees, one set of documents. Second, you have to look at B2B contracts, that is business to business. So when a startup starts making a product or selling it, or starts giving a service, either it is digital or physical, then you enter into what is known as B2B contract, that is business to business contract. Third, you may probably in this course want to know about B2G contracts, that is called business to government contracts, which is also quite important in terms of the title of this course when we talk about tendering and public procurement, because many of these startups may be coming under what is known as the MSME Act, and Rohit will probably deal with that from the session, but that is also a kind of categorization that one should understand. Because as per government regulations, if you notice, small scale industries also have some reservations in procurement and tendering. Every state has its own policy. Some states give 15% for small scale industries. Some states provide 25% for small scale industries as well. Startups are small scale when they start. They can then enter into medium scale and also large scale at the later point of time. But what is now being presented is also what we call as contract within the partners. Right? We are all partners in the business. The kind of entity that you make from a partnership could be a private limited company. It could be a limited liability company, or it could be a partnership under the 1932 Act. So when two or more persons come together, and these could be natural persons or it could be legal person. Natural person is me and you. Legal person could be a cooperative. It could be a society. It could be a trust. It could be a company. It could be a partnership as well. So when two or more persons decide to start a business, they also need a contract to bind them. For example, if someone looks at the Indigo Airlines, that is the best example of why a founder's agreement is very critical. If someone of you have been following Indigo, between the two founders of Indigo, and now one of the founder has slowly agreed to leave the company and hand it over to the other partner, a founder's agreement becomes very critical and relevant in such cases. Because once the business is small, the founders may have quite a good understanding, but once it starts growing, the founders will have differences. This is inevitable. And when the differences are there within a family, between a husband and wife, it is quite obvious for differences to come when business is growing, about business strategy, about the scale of business, the volume of business, whether the business has to go and become a public limited or not, whether the share should be listed or not. All of these could be differences. And hence a founder's agreement is critical so that you protect the interest of the business. You also clarify the roles and responsibilities of the partners who start the startup. This is also a different kind and nature of a contract that is essential to build the momentum of a startup. So that is what a founder's agreement is. So different types of contract have different purposes. They have different objectives. Hence, they'll have different clauses. And hence, each of these should be evaluated. And of course, the foundation law on all of these contracts is the Indian Contract Act 1872. So, in India, we have not created, a contract law for every kind of contracts. The foundation law is there, the 1872 Indian Contract Act. But of course, when it comes to B2C contract, now this is what we call as business to consumer contract, we have the Consumer Protection Act of 2019, right? So, whereas in other kinds of contracts, we do not have a law, and the basic law is the Indian Contract Act that governs that kind of relationship, right? Now, you will also notice that such kinds of, kind of partnership is also known as joint ventures at times. That could be another element that someone would want to talk about it. When you talk about joint venture partners, then you could also talk about public-private partnership. PPP, as we call them. This is on a higher scale, right? So that those are definite possibilities as we go further in the business processes as well. Rohit, you can continue.
Yes. So, as sir suggested, there are certain aspects which MSMEs have, which we will be discussing in the coming slide. But before we move on, at the stage of entity registration, so we are speaking about this particular juncture to understand how MSMEs or startups, because of their internal constitution, in case there's something goes wrong, can it affect their stage in public procurement or otherwise? Yes, of course it can. So that is the reason it is always necessary to have a framework in mind to ensure that businesses are governed on a particular framework. So under the entity registration, I think like how Pratyanik mentioned, that there are different entities that are there. So one is a sole proprietorship where there is only one person who is doing the business. Partnership includes two or more people coming together to do a business. So the difference is, in case of a sole proprietorship and a partnership, there is no separate existence for the business. So the business and the people who do the business are one and the same. But in case of an LLP, that is a limited liability partnership, or in the case of a company, which could be a private limited company or a public limited company, the entity and the business and the people who do the business are different from one another. So there is a legal personality created for the business, which treats them as separate. That is what we call the process of incorporation. So for incorporation, we have several documents. Sir gave the instance of the Indigo, wherein there was a founders agreement in place. Now, is founders agreement a mandatory document? No, it is not. But having it as an additional compliance document is always helpful when businesses decide to lead the forward path or the succession plan. Yes. So over here, once you decide what is the nature of business, you can also choose to register for your MSME registration under the Udyog Aadhaar or your Udayam registration scheme. And that is one of the particular aspects. So there are different compliance aspects that come to your purview in case you're going to go ahead with an implementation perspective. So depending upon the type of the entity, the scope of the operations, and the span of clientele that the startup has, the nature of contracts vary from one to one. So like Sairam sir suggested out, it is either a business to business contract, or it could be a business to consumer contract, wherein you enter into, say for example, in case of a software agreement, you have something called a SaaS based contract, which is called software as a service. In case you are a entity which is selling goods, then you might have something called a distribution contract. So that is the nature of contracts that depend based on the number of clients or the nature of activity that you carry. Then choice of revenue models. Yes, in case you are looking across for loan or a financing or a debt model, then you might require to have a loan agreement or a hypothecation agreement. And in certain aspects, in case you're deciding to give ESOPs, that is employees sweat equity or stock options schemes. So you will also require to have policies in place under your law so that you can carry out the same. Then depending upon the branding, like say, for example, I'm sure that each one of us has an eye for brands. So in those circumstances, what happens is, depending upon whether you are taking the brand of another person and using it for your services, you might take across a franchisee model of contracting. Okay, so depending upon that, you can pin in the liability and determine the aspects as to how brands are also dealt with by the startups. Then moving further, we also have certain aspects like with regard to the strategies that you adopt. Now, as you grow as a startup, a lot of requirements or additional documents come into place. Like say, for instance, your compliance under various laws like your anti-sexual harassment law, So you might require to have an anti-sexual harassment policy for your entity as well. So these are various aspects that deal with you so that you are in compliance with the law. Because please note, when you are not in compliance with the law, what happens is your eligibility in the case of a tender becomes a question mark. Your eligibility to apply for a public procurement becomes a black spot. So in those circumstances, what happens is you must always ensure that you are also on the right side of the law and you're also in compliance with the requirements of the law. So having your requisite policies in place, like say, for instance, right now we have this rush on privacy policies. Okay, because of the outcome of the GDPR and the privacy judgment, we have a rush on this particular aspect. So if you are actually dealing with third-party data, there might be a necessity for you to have a proper privacy policy in place as well. So those are aspects that you need to definitely look into while you're going ahead from a dining table to a boardroom strategy. And lastly, coming up is one last aspect that I would be dealing on the requirement of contracts is pinning of your liability. Now, as a startup, the amount of liability that you're exposing yourself to while doing a business is quite large. So in those circumstances, should you always have an insurance agreement or an indemnity contract? Because this is something that most of the startups tend to not look into. They tend to not take it thinking that, oh, insurance cover is slightly expensive, so let me not take it. So a couple of insurance policies like key man insurance policy. If somebody who's working as a managing director in my company is going to resign tomorrow, in those circumstances, if I have a key man insurance policy, I can get an indemnity cover. Because a lot of times what happens is you have to give them paychecks, fat paychecks while they leave. So in those circumstances, a key man insurance cover helps you meet out your time-bound liabilities which happen on in case certain employees leave the company, or in case you are leveled with some aspect of product liability or otherwise.
Rohit, just
Yes.
want to ask you one thing, just to add out I read. What is the difference between an insurance and indemnity? Are they not the same thing?
Yes, they are the same. Indemnity contracts are much broader. Insurance is one of the forms of an indemnity contract. Now, an insurance contract is something that you execute with an insurance agency who is a third party who agrees to make good the liability for you. Now, indemnity contracts need not always be with third parties. Indemnity contracts can also be with your employee. It can also be with your service provider. Like say, for instance, you are a person who is manufacturing biscuits, okay, and you order, say, the packaging commodity from Rohit or Vikas, okay. So in those circumstances, if you receive a damaged packaged commodity because of which the quality of the biscuits get affected, and day after tomorrow a consumer case is filed against you, in those circumstances, either Vikas or myself will have to indemnify you for the loss that you have incurred because of the product defect in my packaging commodity. So that is what indemnity is about. In other circumstances, you can also have an insurance cover for this. In case there is a product liability, when you're not able to say that it was because of either mine or Vikas's fault that the liability incurred, in those circumstances, insurance companies will also make good the loss that you incur. So that is how it is. Hope it answers the question.
Yes. Rohit, just one
Yes.
more question. What
I
is
think because
yes,
I
sir.
think you should now move on to the case study, because we should have to cover both of them. So I think the questions can be put in the chat box, but please move on to the tender case study, please.
Yes, sir.
Vikas, over to you, Vikas.
Thanks, Rohit. Mr. Rohit, thank you for making such a brilliant presentation. Coming to the case study that we will be discussing. 1 second, let me just share my screen. Friends, the case that we are going to deal with is the Center for Aviation Policy, Safety and Research versus the Union of India. This was a writ petition filed under Article 226 for quashing of request for proposals. Now, friends, as we all know, a government contract is a special type of contract. And one of the speciality of this contract is that it can be subject to the writ jurisdiction of the high courts under Article 226. So when any government authority or agency drafts a request for proposal to call for submission of tenders, that can be taken to the high courts and can be disputed upon also. So in this case, the airport authority of India issued a request for proposals calling for service providers for GHS services, called the ground handling services. Let me ask you one question. How many of you have been to airports? How many of you have been to airports? Pratank has raised hands. Samuel has raised hands. Okay. Friend, let me ask you, have you seen what is GHS? Have you heard of somewhere? What are GHS?
It's ground handling services,
Yes.
which
you
is
think of something?
which is
What can
provided which is provided by the airport staff for carrying luggage, carrying goods, and for many things related to for transportation inside the airport. So these are the ground handling services.
True, sir. So friends, as Sir has said, ground handling services are very integral part of the activities that are taken in the airport. They include simple services like loading and unloading cargo, traffic handling and all. So question comes, who undertakes these services? These services are undertaken on contractual basis. So when the contract of these services was how to expire in 2020, the airport authority issued a tender notification, a request for proposal, asking for the bidders to submit the tenders. Now, friends, the interesting thing with this request for proposal was, first of all, the airports all across the country were bifurcated into 4 parts: A, B, C, and D. And the D part was bifurcated into other 2 groups, D1 and D2. The A group was your metropolitan airports like Bangalore Airport, IGI Airport, and all. C and D airports were small airports that are in different parts. Now, categorization of the D1 airport was done based on the different regions like North, South, Northeast, and Northwest. The interesting condition that was laid down in this request for proposal was that in A, B, and C category, you can file your bid for a single airport, while for D1 airports, you have to file for one region like North region, Northeast, and South region. This clusterization was never happened before. So far, every tender that has been submitted and asked was on an airport specific basis. This was the first time the airport authority decided to do this type of bifurcation. Secondly, the technical eligibility that was laid down was that the bidder has to have a 36 months of experience in providing at least 3 of the 7 core GHS services in the last 7 years. Now, this was the main condition. When the when the request for proposal was drafted, this line was mentioned, but not in the main part. And the main part, this line was mentioned, and in the annexure part, they mentioned a specific condition that the bidders have to provide a certificate in this contest that they have provided this kind of services for scheduled aircrafts. Now, friends, this condition of providing the certificate for scheduled aircrafts was not mentioned anywhere in the main body of the request for proposal. And for B1 airports also, this was not mentioned. Only in the annexure and the format of the certificate that the bidders has to submit, only this condition was laid down. You know why this makes a difference? Because Group D airports do not have scheduled aircrafts. They are non-scheduled aircraft. So the person or the agencies who have been providing GHS services so far in D group airports have no experience for scheduled aircraft operations. Secondly, friends, the request for proposals also required that a bidder may submit its proposal either singly or forming a consortium of maximum 3 entities. Now, why only 3 entities? That was the condition laid down, and it was disputed in the notification also. Why maximum 3? This will make sense when we read the financial criteria mentioned in the document. It mentioned that the annual turnover of the bidder has to be more than 30 crore rupees in 3 financial years. This is a huge amount, friends, and small and enterprises that were providing the GHS services so far at D airports, at the Group D airports, did not have that amount of turnover. Not a single agency has. And as Rohit was talking of the MSME Act, if you have read that, friends, the annual turnover, the maximum annual turnover of an MSME can be 5 crore rupees only. If your annual turnover is more than 5 crores, you are not an MSME. So, friends, as per the technical qualification, even if 3 MSME form a consortium, still their turnover could not meet the financial criteria laid down by this request for proposal. The grievance that was raised before the High Court, first of all, that the document has made a radical departure from the past. It's not a simple departure, but a radical departure. And the technical and financial qualification that has been laid down, it hinders or it disqualifies most of the existing GHH agency that have been providing services so far to Group C and D airports. Second, friends, they argued that the technical and financial criteria laid down has no correlation with the GHS services that has to be provided to these airports. They said these conditions are arbitrary and exclusionary in nature. Before we go to the defense that was taken, friends, let me ask you, can courts interfere in the matter of determination of eligibility criteria, or can they not? This is my question. We all know that the high courts can interfere in that tender contracting, but can they interfere in the determination of eligibility criteria, or is it a prerogative of the airport authority or the tender issuing agency to determine what should be the eligibility criteria? So friends, what do you think? To anyone from the government sector or who has given, I think Rohit wants to add something.
So my question was, can governments ensure that the eligibility criteria is defined in such a manner that only one or two businesses can fit in? If we say that the courts cannot interfere, the counter of this is that the public authority can ensure that the eligibility criteria is drafted in such a manner that majority of businesses are just excluded.
So friends, Rohit has made one point, but do you all think, can the courts
Sir, may I?
interfere in this? Yes, I think. Yes.
Yes, sir. So,
Go
in
ahead.
case of government contracts, the
Mhm.
government has to abide by the fundamental rights. And
Mhm.
in that case, sir, under Article 14, they cannot take any arbitrary action.
Mhm.
And saying as such eligibility that we just saw, they are basically taking an arbitrary action, and thus the basically the contract is against public policy and against Article 14.
Okay. And anyone else?
Now, let us first clarify that this is not about contracts. See, tendering process is pre-contractual. It's not contractual. Contracts, can they be challenged on the grounds of public policy? The answer is yes. If you go by, again, the foundational law of India, that is the Indian Contract Act 1872, yes, any contract can be challenged as being opposed to public policy, and the judiciary has the right to intervene and determine and test whether it can be a permitted contract or it should be held to be not permitted or not enforceable contract. Here we are talking about pre-contractual. This is a tender condition. These are tender eligibility criteria that have to be fixed for the bidders to actually fulfill these criteria and then submit their bid. And of course, the government will evaluate the bids, select the most eligible one with whom such a contract would be made. So please understand the distinction between contractual challenge and pre-contractual challenge.
Yes, sir.
Sir, I think
Yes, sir.
Government can make this a prerequisite,
Mhm.
because this is as per the documents, as per the experience of the government servants. So at the pre-A1 stage, that means you have not got the RFP is not released, but pre to RFP, all these criteria are discussed, and all financial things are discussed with all the facets of the government. Like it goes to finance, like it goes to everywhere. And from after consulting them only, we put all these things in
Yes, sir.
contract.
Yes, sir.
But at the
So-
same time, Ahuja ji, you must remember that what is contract in government? Ahuja ji, you will understand contract is an executive function. Please refer to Article 299 of the Constitution of India, which actually states the same and vests the highest executive authority or power with the President of India and the governor of this particular state. So while we say in government there are three functions, one is legislative, second is executive, third is judicial function. Contract making power is an executive function. Having said this, executive functions and tendering are in terms of the fact that, look, this is a kind of an administrative action that is being taken. And once you're taking administrative action, are you subject to judicial scrutiny, especially of the constitutional courts under, say, Article 226 vis-a-vis the High Court and Article 32 in the Supreme Court of India? The answer is yes, judicial scrutiny is necessary for administrative actions, for executive actions, so that those executive and administrative actions are not unfair, are not unreasonable, and don't amount to an arbitrary action. So judiciary it's the check. It balances executive action whenever executive action is probably abused, misused, or probably to one extent you find over reach of the executive action. So I think the judiciary plays that balancing act. What is also important for us to appreciate and understand is, please note, if suppose I'm excluded in a tender deliberately, intentionally, unreasonably, unfairly, there is a possibility that someone like Vikas, who is an MSME, may lose his right to do business under Article 19(1)(g) of the Constitution of India. Every Indian citizen has been guaranteed a freedom of trade, occupation, and business. So exclusionary eligibility criteria affect my right to do business with the government. And hence the judicial scrutiny is a kind of a paramount in terms of balancing and checking so that citizens' interests are adequately protected with definitely the interest and expertise of the government. And probably the judiciary has to play a role and check whether there is any kind of arbitrariness in the same case.
Thank you, sir.
Right.
So, no, as has been told by sir, the judiciary, the courts can definitely interfere in that. But there is a caveat. The courts do not interfere on a regular basis. Like in every tender document, they will come. They can come, but just general matter of practice, they don't come. Wow. So only when the courts find that the tender conditions or the eligibility criteria is wholly unreasonable, has no nexus with the means the object that is being sought, then the courts can definitely interfere in the eligibility criteria. Now, let's me go to the defense that was taken. With that, I will end my presentation. Friends, let's see the defenses taken by the airport authority. First was that it is convenient and less cumbersome to manage a single contractor for an entire region than to manage several contractors for the individual airport. Thus, through one contract, we can cover all the airports. Now, is this an arbitrary decision? Is this an unreasonable condition? Or is this a unacceptable governmental policy? Second defense was taken was that when we operate the aircraft at a regional level and not at an individual level, it will allow for economy of cost to be exercised, and it will reduce the overhead cost also. And then they said lastly that it will increase ease of doing business. Now, friends, what do you think? Is the defense taken by airport authority in developing those eligibility criteria unreasonable, unacceptable? Yes, no, don't know.
Sir, these are obviously not unreasonable
Hmm.
in that regard.
Why so?
Because so at
Hmm.
least the first one and the second one, even at the third one, these are genuine problems the Airport Authority of India will face if they are not making that eligibility criteria.
Friends, the Delhi High Court in this case rejected all of these defenses given by the airport authority. They did not expect a single point that was raised by the airport authority. Why so? First, when we say convenient and less cumbersome to manage a single contractor as compared to several contractors, you have done so only one B group. You have not done in A group. You have not done in B group. You have not done it in C group also. Then why just one group you have done so? Secondly, friends, when you say that it is exclusionary, the court in this case found out yes, it is exclusionary. Why? Because a stipulation that is laid down that you have to have some years of experience in dealing with scheduled aircrafts. No operator who has handled the operation in those airports was found to have an experience of scheduled aircraft. The court find this is not acceptable. You have to give time. If your intention with the policy of the government was to convert these airports into scheduled aircraft also, then they have to give some time frame for these local agency who have managed these airports for so long to develop the experience required for the no for the scheduled aircraft. So with this, I will end my presentation. If there are any doubts, they can please ask.
Let us, because I see Ahuja sir with us. I just wanted to ask Ahuja sir and other participants, what kind of contract or tender was this supposed to be? Was this supposed to be some kind of a procurement of goods contract?
It's a services contract.
Yeah. Now, if it's a services contract, what do you think? 35 lakhs EMD and 30 crores turnover is reasonable?
Sir, see,
Especially for D1 and D2.
no,
If
see,
it was for A or B or C. So I think it's important for us to appreciate the kind of contract that we are looking at. Because again, in government tendering, there are procurement contracts for goods, there are tendering for services, and then you have a tender for works contract, right? So based on the kind of requirement the government has, I think the eligibility conditions and criteria will have to be met. This is very important for us to understand. Second, I think it's also important that the purpose of the court's interference is to only balance the interest of the parties in a contract, and to see that anything that is done by the government is done in a reasonable manner, which means also that suppose the government comes up with any kind of scheme called the Atmanirbhar Bharat, or any scheme in which we must do what we call as vocal for local. I'm sure most of us have heard about all this.
yes,
Yeah,
we have
vocal
heard.
for local. Yeah.
Yes, sir.
So, and we also say, let us promote local businesses. Let us promote, local enterprises. Let us promote MSMEs. Let us generate more employment. I think the government must also practice what has been the mission of the government. And hence, I think sometimes the courts have a reason to, intervene. And I think in this case, it's a classic case where the intervention was necessitated so that a proper level playing field is given to all the parties concerned. And I think the Delhi High Court has laid down and redirected the airport authority to, frame the tenders again. However, like Vikas said, one will definitely appreciate and understand that the courts are not experts in determining technical conditions in a tender document. And in the past, they have hesitated to interfere on technical grounds or the technical requirements. So we have to make a distinction in a tender about the processes and the technicality, right? And there is where the courts will balance between the contracting parties in this matter.
Yes, sir.
Thank you, sir.
You're right.
Thank you, sir. So, friends, as as Rohit was discussing, we have some books, to strengthen your knowledge that you have learned from the MOOC course with these books. The first one is the NLSIU books series 5. That is public-private partnership in.
Because
Yeah.
your screen is not visible, I think you have to stop
Okay.
screen and share it again.
1 second, sir. Now, sir. Okay.
It is visible, sir.
So, friends, these are book. This is the first book, and these are the 2 more books that we have. First one is the NLSIU books series 1. That is the contract agreements and public policy, and the NLSIU books series 2 book. That is the energy law and policy. If you wish to buy these books, you can write an email to us, and we will facilitate a dispatch of this book to you. And if you want to read the books online, you can also do so by visiting our 3 websites. So, with that, I will conclude this session for the day. I will thank Sir and Rohit also for being
Yes,
with me.
before we
Yes, sir.
conclude, there is one
Yes, sir.
query. Is there any material to protect the interest of sellers? I think, I must tell you that it is no longer necessary only a consumer interest or consumer market. I think India is protecting sellers' interest and sellers' market as well. Please don't, have, this, kind of a conclusion that it is only buyer's market, right? We have statements in which we have said, yes, the seller must be where we say, caveat vendetta, that is consumer is the king, no doubt about it. But there are legislations that protect in the interest of the seller. Contractually, if you draft your documents well, if you take care of the clause, and if you take care of the legal language in a contract, I think the seller's interest can be very adequately protected as well. Let's not forget that the ecosystem in India now balances the interest of both the contracting parties. It's not one-sided any longer. And I think that's very important. Just to give you one instance, see, a few years back, we had the rent agreement, which was completely pro-tenant. I hope all the participants would probably agree with that. Now, is the ecosystem, balancing between the landlord and the tenant in India? I'm sure most of you will relate to what I'm just saying, which means I think the ecosystem, the legal system has provided a balancing mechanism to the contracting parties. And there are many such examples that can be shared to protect sellers' interest as well. Right. Well done, Vikas. Thank you so much. And Rohit, thank you. Thanks to the.
Excuse me, sir. I have a question. May I ask?
Yes, go ahead.
Yeah. Sir, I am working in a government company, PSU company, and I have awarded a contract to a proprietary firm. And after initiating work, the owner of contract proprietary firm died. Then how the contract can be closed, or who is responsible for the balance work?
That's a very interesting question. That's a very
Yeah.
interesting question. So, in government, there is no straightforward answer to many of these aspects, but you will notice that, let's ask this question. Suppose you take a loan, and suppose I take a loan and I die. Will my successors be responsible to repay the loan?
No.
No.
Huh?
No.
Are you
No.
sure?
Sir, if the contract recital doesn't says ki Dr. Sharam Bhatt means the Dr. Sharam Bhatt and his heirs, something like that, then
Okay, so my son
yeah,
can inherit my assets, but not my liabilities.
He would be
This,
liable up to the
this is one,
extent of
this is
the property that he is claiming as a
correct,
successor. Yeah.
correct. So contractual succession is a matter of a great debate right now. Let's understand it from government perspective. Suppose a BJP-led government makes a contract, the next government is headed by Congress. Is there contractual succession? There is. Okay. If one company merges with another company, is there contractual succession? There is. However,
Yes.
in a case of sole proprietorship, the
Yeah.
contractual succession in government is a dependent factor. Because let me give you one example. I think these are cases that we have handled on multiple occasions. So you will notice that in our case, the sole proprietorship who had the order from the government, he was an electrical contractor. He died. Now, can I give that electrical contractor to his wife in contractual succession?
No,
Why?
because there is no liability on her wife.
No, liability can be there, but can I transfer it to the wife right now? See,
No.
my problem is I
Yeah.
can do so, but electrical contracting work is a technical work.
Yes.
The husband may have that competency, but if I transfer it to a wife who has no understanding of electrical frameworks or electrical issues, then what will happen to the contract that she makes? So I think it is something that we'll have to understand on a case-to-case basis whether the wife can be made, a successor. Point one. Point two is, let's not forget that the husband has done the job. He has already completed the government tender. Payment is left. Should the payment go to the wife?
Yes.
Yes, that's an absolute yes. I knew a woman answer would be in a very affirmative tone. Yes. So you would say that, yes, she is entitled to that payment. It could be the wife, it could be the son. So I think, sir, the answer
Because
is we'll have
contract
to,
was already performed. Yeah.
yeah, correct. So it is succession to the payment. Correct? Yeah. So it is on a case-to-case basis, sir. We'll have to evaluate and check the nature of the contract at the stage of the contract, and only then come to this conclusion that a succession is permissible in law or not. So there is no straightforward answer. It is something that is to be decided on a case-to-case basis.
In case of payment, sir, wife may get payment, but in this case, is there required to consent from their children?
No, sir.
For the
Sir,
payment?
you are now extending it to land, property, and other matters. No, government contract does not work on those angles.
Yes, sir.
Okay.
Actually, sir, I have to decide this in a real scenario.
Sir, you can
That's why
consult
I'm
us.
asking this.
You can consult us, sir. You can do that. You can just send a mail to Sira, and we can probably guide you on that. Yeah. Anyone else?
Okay. Thank you, sir.
Yes, sir. So I have this question to Rohit sir and Vikas sir. So will the slides for today's session will be shared with us?
No, not to you. There is conflict of interest. You have been our student, and now you are asking for these slides. How can we grant it to you? You have to continue to be our student to access all this.
Sure, sir. I am up for
You
it.
are an exception. You will not be granted.
Okay.
That was it.
Yeah. Anybody else? Okay. Thank you, guys. Thank you to Sira team as well. Thank you to Karthik in NPTEL. Sorry, we stretched a little bit beyond the time, but I hope the session was interesting. Please join us for the next month's live session. That will be the final and concluding live session. Thank you very much. Good night, everyone.
Thank you.
Thank you, sir.
Thank you, sir. It was indeed a great session. Thank you.